Welcome to Law Dogs. I'm your host, Jeff Henley, and with me as always is Annabelle. Now today, once again, we're talking about criminal law, specifically affirmative defenses. Now, there's more than one way to skin a cat when it comes to defending a case. In a criminal case, you can typically challenge the burden of proof that the prosecution has to prove. That is, they have to prove the case beyond reasonable doubt, and the defendant can sit back and just challenge the credibility of the proof, the witnesses, the evidence, and the like. Now, with affirmative defenses, we're talking about something different. Sometimes they are called confessions and avoidance. That is, you're not challenging the proof of the prosecution per se, you're doing something different. In many instances, what you're doing with an affirmative defenses is you're saying, yes, that may be true, but something else is taking place. Stated more formally, an affirmative defense is a defendant's assertion of facts and arguments that, if true, will defeat the plaintiff or the prosecution's claim, even if all of the allegations in the complaint are true. Yeah, I did it, but I had good reasons, one might say. With an affirmative defense, you're not contesting the incident, you're contesting the basis for it. You're saying, yeah, I punched this guy in the nose, but he had it coming because I had to defend myself. An affirmative defense is coming forward with some kind of evidence that negates your guilt for criminality because you have an excuse or a justification. It could be defending yourself. It could be defending a third party. It could be doing some act to prevent some much greater problem. With an affirmative defense, the defendant may have to plead and actually prove his defense. Keep in mind that's very different from contesting the proof of the prosecution. Let's take an easy example. Let's take the one that we're all familiar with from our days in elementary school. Self-defense. Now, with self-defense, it arises typically in charges for assault or various kinds of homicides. And what's taking place is the defendant is being charged with committing some sort of assault against another. But the defendant says, yeah, I broke the guy's nose, but he had it coming. If I didn't hit him, then he was going to cause greater harm to me. Now, the law of self-defense has certain elements. Indeed, depending on the defense that you're employing, it could vary significantly. For example, if you're talking about using deadly force, there are many more requirements the defendant has to establish. The point is you can't just assert self-defense for anything, and you don't have the right to do anything in defense of yourself. It is an affirmative defense that is predicated on specific facts. So, for example, you cannot use the defense of self-defense in response to a theft or a fraud. That is, you can't go beat up somebody who stole from you and say, hey, I was defending myself. Self-defense is constrained by the defendant's fear of imminent bodily injury to himself. Likewise, defense of a third person requires that some third person is in fear or likely to suffer imminent bodily injury. This is our first brush with affirmative defenses. In other episodes, we will go into much greater detail about self-defense and a lot of others. But the idea that I want to emphasize to you is that an affirmative defense is something that the defendant brings up himself. But an affirmative defense can negate guilt and have the same effect as though the prosecution was unable to prove its underlying case. If you have any questions about affirmative defenses or any other thing you've seen on Law Dogs, you email us. Till then, Annabelle and I will see you later. You stay out of trouble or the Law Dogs will get you.